Dear participants, a very warm welcome to this webinar. I'm Professor Pascal Pichonnat from the University of Fribourg in Switzerland, and I'm the president of the European Law Institute. It is therefore my great pleasure and privilege to welcome you all to this webinar on the use of automated decision-making and consumer law. The webinar is part of a series of ELI webinars which aim to showcase the ongoing and completely works of both institutes and their impact. The series will uh, uh, commence with this webinar, and the aim of the present webinar is to engage in a kind of transatlantic dialogue on the use of automated decision making by consumers, but also, of course, traders. To this end, we have a very distinguished panelists, and I'm really thrilled to look forward to what they will tell us this evening. Now, I don't want to take too much time. I just want to mention for the US lawyers on this webinar who would like to earn CLE credit for attending this webinar, that there are two requirements. First, throughout this webinar, you will be presented with several simple polls and provided with 10 seconds to answer. So your participation in these polls will confirm your attendance for the various state bar organizations. And secondly, at the conclusion of this program, please fill out the form that was provided along with the other course materials and follow the instructions on that form to submit it for credit. And of course, after the presentation of our various panelists, we will be able to have a Q&A section, so do not hesitate to pose your questions in the Q&A section. We will not have live questions, but questions in the Q&A. Now, without further ado, give the floor to our first panelist, Florencia Marotta-Vogler. She's the Boxer Family Professor of Law at New York University School of Law and Director of the NYU Law School Study Abroad Program in Buenos Aires. Her teaching and research interests are consumer contracts, electronic transactions, commercial law contracts, and information privacy. Her research explores the legal challenges presented by new technologies and ways of doing business in various electronic marketplaces and beyond. Now, she's a co-reporter of the American Law Institute's restatement on the law of consumer contracts, a much debated restatement that has been approved. And she's also the advisory board on Torquato Di Tella Law School in Buenos Aires, Argentina, as well as the University of Zurich School of Law. I give you the floor and I look forward to listening to your comments.
Thank you very much for such a warm welcome and kind introduction, and thank you for having me. It's quite a pleasure, and I'm looking forward to the conversation and debate and learning from you. What I'm going to do right now is talk briefly about the extent to which the report applies, the ELI report applies to developments in the U.S. and in particular to how it relates to the restatement of consumer contracts, which was jointly co-reported with Omri Ben-Shahar and Oren Bargil and some very engaged ALI members who were instrumental to the completion and approval of this project. So we're very grateful to Steve Weiss and team. So the report that was I read with much interest looks beyond the use of algorithms to make. So we've been talking a lot. There's been much discussion about how algorithms have been used to make recommendations or personalize particular ads or make offers, and how they might be discriminatory or how they might be manipulative in some degrees. And there's been lots of conversation with regards to that. What this report does, which is quite interesting and ambitious as well, but also quite critically important, is to focus rather on innovations that would allow consumers to automate the steps that would otherwise have to take themselves to conclude a contract. So deploy digital assistants who can become perhaps more alert and faithful agents of their desires. So it goes beyond this purely information gathering and actually creating legally binding obligations on the consumer. So as an example, there's this like coffee machines that reorder pods, and that would be great. Or what's happened currently, for example, the Hewlett Packard has its own printers determining whether that they're running low on ink, and they can automatically order cartridges. And in fact, there's a litigation that's happening with respect to that, and we can talk about that in the Q&A. Or Amazon is another example. Amazon allows its own consumers to, it can detect when consumers make frequent purchases, and it gives for certain types of products the option to automate frequent purchases in a recurrent manner. So even today, we're seeing some elements of this deployment of automated purchasing, at least when it, from the vendor itself, which is one of the categories that the ELI report discusses. So there's two main issues that the report talks about, and I'm going to make parallels with US law and the restatement. One is this notion of attribution of agency. So what happens when the actions that lead, that the consumer deploys a legal assistant, and the question is whether the legal assistance, two things that relate to this, whether the legal assistance purchases and actions can be attributed to the consumer, and second is the extent to which consumer law applies to the actions of the digital assistant. And the report deals with it very nicely, and we're going to have discussions over that. The way that this relates to US law has to do with a law of agency, which would, under certain circumstances, which are articulated in the report, would make these actions by the agent attributable to the consumer, and similarly, so agency law can address that, and the other one is the extent to which the types of consumer protections are also available to the digital assistant. And under agency law, that the answer would be yes. So I'll talk about two sub-issues that the restatement would deal with in this particular situation. I'm talking all hypothetically because I'm not aware, and I've looked and I've asked students to look of any cases that deal with this. Perhaps the HP case is one that is somewhat tangential. So one question is the extent to which the digital assistance goes beyond or against the consumer's authority, or the digital assistant does something that go against the consumer interest in this particular case. So this has to do with the first issue, which is the contract between the consumer and the firm offering the digital assistant. And for those types of situations, so one, there's a breach of contract or misrepresentation type claims that would happen and that would be available to the consumer. And then in terms of these contracts, we have to talk about the disclosures that are usually available to consumers for proper formation of the contract with the firm providing the digital assistant. All of the requirements which are currently in Section 2 of the restatement and that reflect the common law development in this area, they should apply because this is a consumer contract, right? So this includes all of these notice requirements in Section 2. The nice thing about Section 2 is that over the period during which we worked on the restatement, which has been the last decade, there's been an explosion of case law that has to do with contract formation. One hypothesis is that because courts have been somewhat constrained in finding that some contracts are unconscionable, they've been focused a lot more on the formation requirements. And that's one thing. And the other thing that has happened that is also quite interesting and relevant for this space is that there's been a lot of innovations in terms of how consumers enter into contracts with businesses, particularly in the digital environment, not just for not in the context of digital assistance, but in mobile transactions and transactions generally online. So there's been an explosion of how these contracts occur. And first of all, because many goods and services have been digitized. So the fraction of our shopping and transaction that have moved online has increased exponentially. And that has also meant that businesses have become quite innovative in how these transactions are entered into. So that has given courts lots of opportunities to address these very novel forms. And what Section 2 has done is has put all of this case law together in a streamlined way that is rather nimble and adaptable to new ways of doing businesses. So for example, Section 2 focuses on the timing, the format of presentation, the context, the process, the flow, and also the substance of the notification. So it's not just about design. So when we talk about, in a little bit, I'll talk about deception and manipulation, and a lot of it that has become quite tied to the design and presentation of things. It used to be about the content of disclosures, and right now it's about how the architecture might actually communicate certain things. Section 2 incorporates that quite well because it talks about the totality of the circumstances. And this totality of the circumstances test gives courts ample opportunities to adapt new contracting situations that might be brought about with, for example, these new contracts involving the deployment of digital assistants. So, so the goal of these court developed requirements have been to afford consumers meaningful opportunity to review the terms and to avoid the transactions and to ensure a valid adoption of these terms as part of the consumer contract. So as I said, they're quite nimble and adaptable. That's an advantage. Of course, in order to do so, we need to see courts engaging with these new forms of entering into contracts to give these types of to give the rules some meaning in this particular context. So we need to wait. So even though the infrastructure is there, we need to wait and see how that is developed once these cases arise. But all of these disclosures should be available, and to the extent that it is the agent, the one that is entering into transaction on behalf of the consumer, all of these disclosures should be available as well. And then perhaps a silver lining of this is that even though this entire apparatus is available to consumers, what we know quite well is that this ex-ante policing and process of mechanism to internalize consumer interest might not be happening so much, even though all of these disclosures are available to consumers, because in reality, nobody really effectively and successfully reads and incorporates all of these terms into their purchasing decision. There's just too many dimensions, too many angles, and especially online, there's just the primary product, there's all these multi-tiered pricings, and then there's the privacy protections that are just not even perhaps a subject matter of the transaction. So this is extremely complex. It happens all the time, and it's taxing for consumers. So this is somewhat fictional in a sense, even though it's fully deployed. Maybe digital assistants can actually use these disclosures to, if done so effectively, and if the consumer can articulate certain types of preferences, do so in a way that serves as some of this ex-ante policing. So that would be that would be somewhat useful. Another type of challenge that occurs at this ex-ante contracting stage is issues that have to do with interpretation. So maybe these new types of contracts have different or new or novel terms, and to the extent there might be interpretation questions, Section 4 of the restatement incorporates the interpretation provisions of the restatement of consumer contracts that include interpretation against the drafter, and of course the mandatory duty of good faith and fair dealing. So again, there are sections. So all of the sections of the restatement of contracts that deal with consumer contracts in particular are reflected in the restatement and deal with these particular types of situations. So I think to the extent that we have that we're dealing with contract formation and disclosure and information available to consumers and digital assistants, that the restatement should be able to handle them, but of course with a caveat that there isn't case law on this in this area, and courts would have to engage with this in order to give us some guidance and give businesses and consumers some guidance as to how to do so. Then the next the second type of contract that the report so deftly addresses is the contract between the trader and the digital assistant. And so these types of contracts pose really interesting questions, because the sellers could potentially manipulate digital assistants in manners similar to what we observe with dark patterns and deceptive practices online. At the moment, the agency that's doing lots of work in this area is the FTC. It has a series of reports that set out some of basic practices for algorithm uses by businesses. But also it's bringing actions against firms. This is Section 5 of the FTC Act against unfair and deceptive practices. And all of this is covered by Section 7 of the Restatement of Consumer Contracts, so bringing many, not only the common law doctrines of misrepresentation that have been operating for many years, but also it brings in a lot of the FTC protections that come into play. And the reason why the restatement does so is that when you look at the case law, when consumers bring actions under misrepresentation or deception, they're brought in together with statutory actions, and courts deal with these in tandem. So it was much more natural to just bring all of this together to make a more coherent sense of this. So many of the innovations that are happening at the statutory level and at the agency level are brought in because they're woven into common law doctrines, because judges are dealing with them together. So these actions are usually brought together, and the restatement streams like this. So it addresses issues of, for example, dark patterns, deceptive business practice, such as negative options, whether clear or easy opt-out or cancellations. But these are not the subjects of the report. But what the report does does address that I think is relevant in Section 7 when it has to do with contracts entered into businesses and bots, is that, for example, deception under Section 7 does not require an intent to deceive. So this is actually quite relevant to this idea of the deployment of bots. Intent is not something that is a part of it, and this is something that's borrowed by the statutory law. For example, there's deception that it is applicable as to salient elements, so element to price, or price that is somewhat obscured, or any attempt to the business to obscure facts that conflict with the consumer's reasonable expectations under the particular circumstances is also equivalent to assertions that these facts don't exist. So the fact that consumer reasonable expectations are at the center of this allows this section to hopefully deal with issues of manipulation that might happen when traders are dealing with bots. Similarly, negative options are also explicitly deceptive under Section 7. I've not properly disclosed and given the chance to cancel. So things that might be used to manipulate even a digital AI, might be a digital assistant, are somewhat covered under Section 7. And the FTC has some really interesting case law with algorithmic disgorgement whenever there's some type of ill-gotten information through the deployment of algorithms. The FTC has forced firms to get rid of all that information, which is somewhat tangentially relevant to this particular situation. And then again is a HP Smart printing case. So that's basically a summary of US law and how the restatement and which sections of the restatement in particular might be invoked and at play when these innovations, and who knows what the final outcome of these innovations will be, but there's enough flexibility and enough degrees of freedom to give courts the tools to address these particular challenges when they come. And of course, they will have to develop the law in the direction that is dictated by these new challenges and innovations. And with that, I'm very much looking forward to what my co-panelists will have to say. So thank you.
Thank you very much. Wonderful. Thank you very much, Florencia, for this very clear and also interesting presentation. The adaptability is central here, and you also stress this issue of interpretation, which I think is key, and is key also to understand what will be presented now by the two reporters, two of the co-reporters. But before, I have to say that there will be a first of our 4 poll questions on your screen. So US attendees, if you are seeking CLE credits, you must answer all 4 polls. And our first poll question is the following. Before today, had you heard of the ALI restatement of consumer contracts? You have 10 seconds. And I hope you've heard about it, because even across the Atlantic, some people at least heard about it. So So thank you very much. Well, do I need to give the answers? Yeah, maybe just to say that we have 57% yes. 57 is more than just random, but it's still one would have expected maybe a bit more, but this is the aim of this webinar as well. So let's continue now and go on the other side of the Atlantic. You mentioned the ELI report, and we will now have a brief presentation of the so-called ADM readiness of EU consumer law by two of our co-reporters. First of all, Christoph Busch, he's professor of law at the University of Osnabrück in Germany and affiliated fellow at the Yale Information Society project at Yale Law School. He's a member of the ELI Council, co-chair of the ELI Digital Law SIG, and a reporter for the ELI project on algorithmic contracts. And he advises the European Commission as a member of the EU expert group for the Observatory on the Online Platform Economy and the EU Consumer Policy Advisory Group. So very much involved on EU level. And we have also Professor Teresa Rodriguez de las Heras Balel. She's associate professor of commercial law at the University Carlos III of Madrid in Spain. She was a Sir Roy Good Scholar at UniDroit in 21-22. She's the delegate of Spain at UNCITRAL for many working groups, and she's also expert for UNCITRAL and UniDroit on digital economy projects. She's an arbitrator at the Spanish Court of Arbitration and a member of the EU Expert Group on Liability and New Technologies, EU Expert Group for the Observatory and on the Online Platform Economy, and many others. And above all, she's the co-author, she's the author of the ELI Guiding Principles of ADM and co-author of this project. So I'm happy to give the floor to both of you. Thank you for being here. I'm thrilled to listen to you.
Thank you very much for the kind introduction, Pascal. I'm very happy to present together with my colleague Teresa Rodriguez de las Heras Balel the main findings of our ELI project so far, and we will address the question whether EU consumer law is ready for the AI chatbot economy. And in doing so, I would like to share a presentation with you, and I hope that you can see the slides. Can you see the slides?
Yes, we can.
Excellent, thank you. So we will address the topic in 3 quick steps. First, I will say a few words about AI chatbots, and then I will try to explain why they create new challenges for EU consumer law. And then Teresa will take over and give you a brief overview of possible regulatory approaches that have been outlined in the recently published ELI report. Let me start with a following dialogue between a consumer and her digital assistant. And I'm borrowing this actually from an American law review a paper by Rory Van Loo. So imagine the digital assistant approaching you and asking, as part of my regular monitoring of your spending, I have located an opportunity to save money on your phone bill and on your grocery bill each month. Would you like to hear more? And the consumer responds, tell me about the phone bill. And then the digital assistant continues saying, based on your monthly data usage and the performance of the networks where you spend most of your time, you can receive comparable service through a different provider at $140 less per year. Let me know if you want to hear more, or if you'd like me to switch your account, place your thumbprint on the phone. So the digital assistant starts a sales talk based on personalized information about the consumer and takes her all the way to concluding the contract. Now, this is a fictitious dialogue, but it's actually not science fiction. Recently, the American legal tech startup Do Not Pay launched an AI chatbot that is designed to autonomously interact with customer service of utility companies through live chat and email and negotiate better conditions for consumers. And just last week, Amazon launched an AI shopping assistant called Rufus, which shall help consumers in finding the right product and to conclude contracts on the Amazon marketplace. And yesterday, it was reported that OpenAI is working on what they call agentic AI systems that can automate tasks like buying flight tickets, for example. So the future might already be here, or almost be here. And the question is, what does that mean for consumer law? Or maybe let me quote another witness in this context, and that is Bill Gates in this context, who recently in an interview said that he expects the emergence of personal agents that understand our communications and give advice, and that we can use these agents for directly purchasing items online. And this has a huge impact on the structure of digital markets. So he concludes, this has a dramatic potential for reshuffling how tech markets look. But what does that mean for consumer law? That's my next point. Well, European consumer law as it stands today is human-centric. That means it is based on the premise that consumption decisions are made by humans. And in this context, consumer law seeks to empower human consumers and to ensure consumer autonomy. But in the AI chatbot economy, things will be different. Consumers will use AI-driven decision support systems to facilitate their consumption decisions. So you can call them, in a sense, augmented consumers. And more consumers may even delegate their consumption decisions completely to AI agents, which then act as algorithmic consumers. And this would have a profound impact on the design of consumer laws. Why? Well, currently, pre-contractual information duties are meant to enable informed decisions. Rules against misleading and aggressive commercial practices shall prevent manipulation of consumers. And the latest layer of EU consumer law takes into account cognitive biases, behavioral vulnerabilities of humans. But AI agents are different from humans. They can process larger amounts of information. What does that mean for pre-contractual information duties? Will this solve the problem of information overload? Can we have less information? Can AI agents digest more information? What about unfair commercial practices? In which way are AI agents vulnerable against misleading and aggressive practices? Do we need a new theory of AI vulnerability? Think of prompt injections or adversarial attacks that could trick your AI assistant into a transaction. And what about possible conflicts of interest? How to ensure that Amazon's shopping assistant is really acting in the best interest of consumers? So we might see discussions like questions about vulnerability of AI systems that we have currently with regard to self-driving cars, where it's a problem that AI agents see the world differently from humans. Will we see this debate from self-driving cars in the field of self-driving contracts as well? Now, this brings me to the Eli project on algorithmic contracting. The project that is behind the report that has been published recently started in 2022. It's conducted by a group of 12 researchers from all over Europe, mainly lawyers, but we also have a computer scientist in our team. The project is co-funded by the European Union, and as you see, we have institutional observers from UNCITRAL, UNIDROIT, and the European Commission. Now, this project team has been analyzing how the use of automated decision-making, ADM, or you could simply say AI assistance, changes the way contracts between traders and consumers are concluded. For this purpose, you have to distinguish two different contracts. Under contract one, which is concluded between a provider and a consumer, the AI system is provided. Then, in a second step, the AI system or the AI assistant arranges the conclusion of contracts between consumers and third-party traders. So you have a multi-party setup that has to be taken into account. At the core of our project so far has been what we call the ADM readiness test. This test involves two questions. First, does EU consumer law provide a suitable framework for the use of algorithmic decision-making in contractual relations? And what, if anything, needs to be done to enable the use of ADM without jeopardizing current levels of consumer protection? So we're taking into account both the enabling function of consumer law as an infrastructure for innovations and the protective function that is, of course, also in the foreground. Now, our preliminary answers to these questions have been published in a report in December 2023, which provides 8 general principles for the use of ADM in consumer contracts, and also a number of specific comments or suggestions regarding amendments of 6 key EU consumer law directives. And the final result, the final product, a set of model rules and guiding principles for algorithmic consumer contract, is scheduled for early 2025. Now, Teresa will give you a brief overview of these general principles. So I hand over to Teresa.
Thank you very much, Christoph. I'm very, very pleased to be today with all of you and to share the main findings of this fascinating teamwork that we are doing on the ELI with these algorithmic projects, algorithmic contract project. Thank you very much, Christoph, for explaining so well and setting the scene that I'm going to use as a starting point, because I would like to dive into these 8 principles. Because in exploring these ADM readiness that the first installment of our project has conducted, we have started to formulate a number of principles that, in our opinion, should inspire and be the foundation of consumer legislation enabling the use of ADM in business-to-consumer transaction. So in order to do that, there are at least 8 fundamental principles that should vertebrate, should articulate consumer legislation. Let me just please share my presentation in order to provide you with some illustration. In these 8 principles, the first one that for us is absolutely key, because it's around this principle that we can confirm indeed the mere applicability of consumer protection legislation to algorithmic contract, is the principle about attribution. We have certainly discussed in depth how to configure the relationship created between the consumer and this digital assistant. We have naturally explored and considered carefully the possibility of using agency as a proper mechanism in order to see to which extent there is an interplay and therefore a consequential attribution of the action performed by the digital assistant to the consumer. But there are many complexities, and there are many nuances, and there are many, indeed, criticisms that could be raised in this regard. That is the reason why Principle 1 is essentially a set of factors that we consider facilitating in a sufficient way the attribution of the digital assistant action as well as decision to the consumer. In order to attribute these actions and decisions to the consumer, we believe that a mere factual notion of use might not be sufficient. Simply using a device that is in your home, simply driving a car that you have rented for the purpose shouldn't be enough. It's not sufficiently qualified to conclude this fundamental legal effect attribution of actions and decision. That is the reason we believe that has to be qualified by 2 fundamental components: the idea of control, some kind of control of the consumer over the system, and if we could say an intentional element, a kind of purpose. So the consumer realize that is using under its control a device, an AI system with a particular purpose. The purpose that is indeed negotiation, conclusion, performance, terminating a particular contract. And in this regard, we believe that apart from certain legal provision that we suggested, we should as well work on certain design requirement that could be indeed provided for by those kind of regulation that could indeed impose on manufacturers, providers, or vendors the compliance with certain design requirement. And these design requirements, as you can see, are in a way justifying, confirming that the consumer has a level of control over the device, the ability to set parameters and criteria, the opportunity to object or hold the contract, or the ability to suspend or disconnect this particular smart functionality in the product. Once we confirmed that we can attribute actions and decisions to the consumer, we immediately go to the second principle because it's a natural consequence. Therefore, we can apply consumer law to algorithmic contract. So there is not a change in the condition of the parties. And that implies naturally as well the very important pre-contractual and contractual information duties that are on the side on the trader. And why is that so important? Because when I mentioned before this idea of attribution, we're talking about the attribution of the legal effect of the actions and decision adopted by the digital assistant. But at the same time, we should continue exploring as well the attribution of mistake, the allocation of risk, the attribution of information as well. Our provisional conclusion has been information duty should not be changed so far and should still be complied for by the trader in order to avoid a situation of unexpected asymmetry. Even if indeed that is not completely satisfying, because as Christoph explained before, we know that this kind of digital assistants are indeed enhancing the accessibility of the consumer, the ability to process information by the consumer. Should that entail a change in the information requirement in consumer protection? If we assume, and I'm going to conclude in a minute or two, not more than that, if we assume that these digital assistant may be reinforcing the bargaining power, the position of the consumer, we immediately go to principle 4, that we are particularly proud of this. Why? Because if this kind of digital assistant are reinforcing, fortifying the position of the consumer, we need to ensure that the trader is not using mechanism precisely to impede, prevent, render impossible or unfeasible the use of this digital assistant. And that is, for example, one of many examples that we have proposed in our report, considering unfair, presumably unfair terms, those kind of terms that the trader could include in order to prohibit, limit, or subject to inadequate or discriminatory condition the use of digital assistant by consumer. There are a couple of principles more that I would like just to conclude in a minute. The principle 5 is about disclosure. In the ADM principle that we adopted in 2022 in ELI, we propose as well this general idea of transparency based on the idea of disclosure, the fact that the consumer, but also the trader, is well prepared if he's aware that the other party is assisted or it simply has delegated, if I may use the word, to the use of a digital assistant. But let me just conclude with 2 other references. As Christoph mentioned before, when the consumer is using digital assistant, we have a new facet of vulnerability. Indeed, the AI vulnerability, the vulnerability of the digital assistant itself. So the concept of manipulative or exploitative practices that usually, as Christoph explained before, were human-centric, therefore directed to manipulate the final decision of the consumer, could be now transformed in actions against the digital assistant. And therefore, we have to be sure that indeed the legislation is well prepared to prevent that. And naturally, there is a final principle that is as well extremely interesting and enticing, the idea of conflict of interest. how can we guarantee and what kind of terms we need in order to ensure that the system provided with the contract number 1 that Christoph mentioned is not creating a situation, particularly undesired or unwanted situation of conflict of interest in relation to the digital assistant and the interest of the consumer. I conclude here, very, very happy to discuss further any point that you may wish to discuss together. Thank you very much.
Thank you very much, Christoph and Teresa, for this very interesting overview of these 8 principles and also of what is at stake here in this project. Some people may ask themselves, we spoke about readiness test, and of course, then you have the implementation on the various directives and regulations of the EU to see whether these principles adapt or not, but that would be too technical to present here. But I can just refer you to these wonderful discussion of each principles in their specific context. So thank you very much. We will continue now with some reflection on the US legal framework and possible developments. And I have the pleasure to give the floor to John Linarelli. He's professor of law at the University of Pittsburgh School of Law. His research in contract and commercial law focuses on debt and inequality and on the effects of artificial intelligence in shaping contract law, exactly what we are looking today at. His work is comparative, transnational, and interdisciplinary. Professor Linarelli is co-editor with Teresa, in fact, of the Hart Studies in Commercial and Financial Law book series published by Hart Bloomsbury. He has served in senior faculty positions on both sides of the Atlantic. He is formerly professor of commercial law at the Durham University in the UK, where he was co-director of Durham Institute for Commercial and Corporate Law. And he is an elected member of the American Law Institute and a fellow of the ELI. He holds a PhD in philosophy from the University of California, Riverside, where he was a Dean's Fellow, and a PhD in law from King's College, London. Professor Linarelli, dear John, you have the floor.
Well, thank you very much, Pascal, for inviting me to do this, and also for accommodating our time difference. I realize it's very late for all of you in Europe, so thanks very much. Just a point of reference, I saw in some of the adverts for this that I was listed as an advisor on the restatement on the law of consumer contract. Actually, I was on the members consultative group. That's a very different thing. So, consider me an impartial observer in the whole process, and taking it on board. I really have taken to heart Christoph's and Teresa's presentations about, I think, honestly, we are somewhat behind in the United States in looking at these questions from a more regulatory standpoint. So, we're looking at it from a contract sort of, if we still believe in those distinctions between contract and regulation. Our focus here has been somewhat more on the contract law side, although as Florencia has pointed out, the FTC has been active, the Federal Trade Commissioner, and looking at these questions. I hope that U.S. regulators take a look at what the ELI is doing, because it's significant. I want to start with a significant data point that Florencia made in an article in 2014 with their co-authors Yanis Bakos and David Trossin. It was a great article. It's called "Does Anyone Read the Fine Print?" And it was an article in the University of Chicago Journal of Legal Studies. It was an empirical study of the extent to which potential buyers of software read end-user license agreements. There were two data points. They were descriptive data that struck me there. One was about 0.2% of shoppers access the agreements for at least a second. I thought, okay, I know I'm not one of them, by the way. And the other one, and I'll quote her, was the highest fraction of readers among retail shoppers across all shopper in session definitions is 0.65%, or about 6 readers for every 1,000 shoppers. That's on page 22 of the article. That's absolutely astounding to me, but totally expected. Even professors of contract law like myself don't read anything. And so, I tend to look at commercial and consumer law around what I call the sort of a tragedy, which is consumers don't read, point number one. Point number two, they would not understand the terms and conditions even if they did. And number three, they need protection, but regulation is really difficult. It's really hard to regulate content. I mean, I think it's hard. Disclosure, does it matter? I don't know. But they need protection. So I think a common point of departure in all these discussions, transatlantic discussions, is, how do we make the law more protective, or how do we protect consumers in a way that does not violate their autonomy to make decisions on their own? Now, the perception, I think, has been, if you look at some of the literature on this, is that EU law tends to be a bit more protective of consumers. This may be true. I think it's difficult to assess. It's hard to say. I mean, this may be less about, I think, about political preferences or anything about the social differences in the social contract between Europe and the United States, but more about institutional design. There's just much more of a public law model of regulation in the EU. So remember that what we're looking at when we look at the restatement on consumer contracts is the common law of contracts of the 50 states of the United States. And I used to love when I was a professor in the UK, people would ask me what American contract law was, and I'd say, I don't know what you're talking about. Would you like me to cite the restatement to you? Because, it's really, the common law is defined along what the court's, state law is doing. So, the sort of more perfect analogy would be if we were to decide to take a look at the principles of European contract law that were drafted some time ago and see if we could carve out a set of rules that are relevant to consumers, and look how the case law, or not case law, but maybe the civil code has sort of evolved. Interpretations have evolved in the UK, but in the EU, in the EU member states around consumers. That would be sort of a more analogy of a perfect analogy. But also, the US, as Florencia has pointed out, does deal with this contract regulation divide, but differently. There's the Federal Trade Commission. There's also the Consumer Financial Protection Bureau, although it deals more with credit cards and mortgages and finance, but it's pretty active, at least when there are democratic administrations. And interestingly enough, that bureau was inspired by an article co-authored by one of the restatement reporters. Orrin Bargill co-authored a piece with Elizabeth Warren called "Making Credit Safer," and which Obama apparently read and inspired the creation of this bureau, which has its good days and bad days. In other words, when there's a Republican in the presidency, there's an attempt to kill it. But when there's a Democratic administration, there's an attempt to keep it and making it active. So, but let me return to the new restatement on consumer contract law. I mean, I'm in the process now of editing my casebook on a casebook I've undertaken on contract law. I'm going to put it in there. It's necessary to get this in there so people understand what's going on. It's a restatement of contract law. I mean, read the handbook for the American Law Institute reporters on what a restatement is. And there was quite a bit of controversy and for a while on what was happening. They used with the restatement. But the handbook says that restatements are supposed to be analytical, critical, and constructive. So the words that the handbook uses is discern the underlying principles while seeing each subject clearly as a whole. Look for coherence. I'm just quoting the reporter's handbook. To restore the unity of the common law. Scan the entire field. I know Steve Weiss did a the member of the Allied Council, was a big supporter of the restatement, did a little a newsletter note on the 4 principles that should be followed, which he took right out of the handbook in terms of drafting a restatement. So I think, you know, this is a really interesting and good and valuable product that engaged in a lot of synthesis of the law, despite the barrage of criticisms, which you expect. You know, I also, if you took a look at the restatement third of agency, for example, the reporter, Deborah DeMott, and the reporters got rid of inherent agency. So I can't teach this little English law case I used to teach. I mean, it's still relevant, I think, but it also got rid of master servant language in the restatement. This is what restatements do. They synthesize a lot of law and try to come up with the movement of the courts in this area. We may or may not like what the courts are doing, but they are doing it. So just some commentary, I would say, on the substance of American contract law in general and the restatement in particular, I will offer. One, there has been for a long time, I'll use the words of Margaret Jane Radin, and this is from a piece she wrote back in 2000 in the Indiana Law Journal. There's been a move a long time away from what we call, you know, contract as consent. The idea, if you look at the restatement second of contracts in the United States, the sort of general restatement, which dates from the 1980s, I believe, which is all over my casebook. You know, they talk about bargains, contract as bargain. You know, nobody really believes this anymore. So now we have this move to what Margaret Jane Radin calls contract as product. You know, I tend to put the focus of that discussion in insurance contracts. You know, when you buy insurance, you're buying legal terms and conditions quite explicitly. That's what you're buying. I mean, insurance is a legal, and it's an invention of the human mind. It's just, you're just buying a contract. And so you know what you're buying when you buy insurance. If you don't like what you're buying, you move on to another insurance company. So this has been with us for a long time. So consumers are basically buying legal terms. You know, part of what they buy is reputation. For example, you may hear people drilling and pounding in my house here because I'm doing some construction of a bathroom in this old house I own in Pittsburgh. I go on Amazon and buy stuff, right? Why? I know I can return it. You know, Amazon has incredibly liberal return policies, which are very helpful. Have I read the contract to discern the meaning of the semantics of their return? No, I just know that they do, just through repeat contracting and reputation. So there are some, you know, really interesting concepts in the New American Restatement, I think, which as an old contract professor, I would say kind of struck me, but, you know, I read the case law and I see it. And I think these are interesting synthesis. One is section 2, which Florencia pointed out, which is called adoption. Again, this is not a word we typically see in contract law, but read the case law and look how this concept of manifestation of mutual assent really has sort of, you know, doesn't really hold the currency that it once held. I think consumers, and the reporter's notes quite rightly talk about this, talk about manifesting and assent to the entire transaction. That's how I look at manifestation of mutual assent. Whether I choose to read or not the terms is up to me. Section 2 talks about giving consumers a reasonable notice of the term and a reasonable opportunity to review it if that term is available for review. Now, if that term is available for review only after you manifest assent, you also will get a reasonable opportunity to terminate the contract. In other words, you can say no. Now, that's fine. I mean, I believe that reflects current American contract law or the case law in the States. But I would just step back a bit and critique that, not the restatement, but contract law. And I think there's some points I want to make about that, which is that if disclosure doesn't matter and consumers don't read contracts, then why put the risk on the consumer? The standard kind of law and economics approach to this question is to respect revealed preferences, you know? In other words, if consumers don't want to read contracts, they don't want to read contracts. That's the choice they have made. But if consumers are not rational or aboundedly rational, then how do we accept this argument? Disclosure really can't matter. I mean, I think this is a vestige of rational choice theory that we need to really look at. Consumers are not rationally ignorant. They're just ignorant. I don't know how else to say it. They just, you know, I think it's difficult to make that argument. I think consumers are manifesting assent to blanket terms. I mean, we all do it, or are adopting what the restatement calls non-core terms behind what we might call a veil of ignorance. They are not experts on the legal consequences of these terms. I would say these terms are not core terms until they are, right? Until there's a dispute. So why hold them to these? The business has superior information again. So we are designing contracts around rational people that cannot rationally exist. I would just say, though, that that's the limits of contract law. We can't ask contract law to do things it cannot do, right? This is a matter for regulators, not for contract law. So I'm not critiquing in any way what the restatement does. It's restating the law. That's what it's supposed to do. But I think this is a job for the regulators here. And regulators really should look at the ELI report closely. Having said that, I would say that given the current kind of stalemate we have in the United States in the regulatory and legislative side of things, you know, I think the EU is going to end up taking the lead on many of these questions for the time being. I love this reasonable opportunity to reject the entire contract, but I wonder if in the future, you know, the whole accept or reject thing is great. That though shifts the power to businesses in some way. It's an example, I think, of contract as product. But why not give the consumer the power to reject terms rather than reject contract? I realize the transaction, the cost of that would be significant, but artificial intelligence and big data, every day there are significant advances in these fields. And perhaps a regulator could look at these questions more closely about how easier it might be to get back to the notion of contract as bargain in some way. You know, again, all of this has to do with the fact that we're talking about contract law. I love the section 6 on unconscionability in the restatement. It's great. It fills out the data on what is unconscionable. Am I running out of time? Let me know.
Yes, you are over time. So
and I love
if
the
you can wrap
deception
up.
thing. And I just want to say one thing about the deception thing. It kind of dovetails between 2207. Us American lawyers will know what that is, UCC, and kind of misrepresentation, and it's fantastic. So anyways, thanks very much. I'm done.
Thank you very much, John. It was really very interesting also to see the tension between empowerment on the one hand and autonomy of will, and then the whole issue about regulation. And of course, we will, if we have time, come back to that in the discussion. I have to run a second poll, so please bear with me. So for the US attendees, you must answer all 4 polls. So if you have done for the first one, do it for this one too. And the question appears now, prior to today's webinar, had you heard of ELI report on EU consumer law and automated decision making? And you have 10 seconds to answer. You may not use your bot to do that, though, if any. Okay. Well, I'm not supposed to give all their results, but here it's 49 yes and 51 no, which is interesting too. I'm sure things will evolve afterwards. Now let's continue with our last but not least speaker today, Jenny Mary Patterson. She's Professor of Consumer Protection and Technology Law and Director of the Center for AI and Digital Ethics at the University of Melbourne. Jenny's research focuses on consumer protection, consumer credit, regulatory design, and the unique regulatory challenges artificial intelligence poses. And here we are really in the midst of what has just been addressed also by John previously. She has written extensively on these topics, as well as teaching on the regulation of AI. So I'm thrilled to give you the floor, Jenny, and look forward to listen to what you will tell us. Thank you.
Well, thank you so much for having me. It's lovely to be here. I'm actually in Hong Kong at the moment, so talking about Australian law from Hong Kong. And I'm just going to share some slides, I hope. So can you see those or not?
We see part of it.
Just see if I can fix that.
Yeah, and then press on. Yeah.
Press on presentation if I can.
Yeah, exactly. Would be good.
Give me 1 sec to do that. And
yeah.
There we go.
Yeah,
How's
looks
that?
great. Yeah, thank you.
Lovely. Okay, so Australian law is influenced by both. Australian consumer protection law is influenced by both the EU and the US, and we have borrowed from both regimes in our statutory consumer protection law. So the reading of the restatement and the Eli report is very interesting from an Australian perspective. I'm going to comment mainly on the recommendations or the principles in the Eli report, simply because it's a regulatory regime that would be influential, I think, on the approach to digital assistance assisting consumers. But I'd say that I found the restatement fascinating and a somewhat more robust approach to consumer contracting than I think we'd have in Australia, which is very influenced by equitable doctrines, in fact. So it's a nice comparative piece, I think, for us. Anyway, so consumer digital assistants have been great topic of conversation in Australia for the opportunities that they may present, which is brought out in the report. So improving contracting efficiencies, which has been discussed by the previous speakers, but also addressing the concerns that were highlighted in John's presentation about inequality of bargaining power and information asymmetries that arise in standard form contracting and indeed algorithmic contracting. So it's a topic of great interest. Of course, there are risks when we're thinking about digital assistants stepping into the consumer contracting framework, which are also beautifully addressed in the report. And I was particularly interested in the idea of poor or predatory design by the provider of the digital assistant and the focus on the contract between the provider of the assistant and the consumer as a topic of regulatory attention. As well as the possibility of exploitation by the consumer's digital assistants by the business with whom that assistant is contracting, which is contract 2 in the discussion in the report. So I like the way it identified both of those relationships, the creation of the assistant and the transaction by the assistant as focuses of attention. I note cyber vulnerabilities are a concern for everyone, but they almost need addressing by a different regime, I think. So the report resonated, I think, with a lot of law in Australia, at least in the regulatory regime and indeed the contractual regime. So I haven't talked about all of the principles, but I just thought I'd single out a few principles I think that resonate in Australia and then talk about some areas where we might want reform. So principle 1 is about attribution, and the previous speakers have spoken about attribution where a digital assistant is contracting on behalf of the consumer. I think that causes no problems in Australia without the need for reform. There's quite a well-known case from Singapore, also a common law jurisdiction, Coin and B2C2, which involves algorithmic trading contracts, and the court there had no problem at all at seeing the algorithmic contracting process as a tool that's operated, is a tool of the contracting parties, and there was no problem of attribution and indeed no problem of assigning equitable doctrines and contract doctrines to the parties who were sitting behind those algorithmic contracts, even though they weren't directly involved. So I think that that's straightforward in Australia. I liked Principle 5, which is disclosure of the use of digital assistants by the parties when they are contracting. And again, in Australia, we've actually had case law on this, where failing to disclose the existence of algorithmic processes is probably misleading conduct. And I think the US FTC has also been very strong on the need for disclosure, even aside from that California Bot Act. And I liked the way Principle 5 turned this into a design requirement. And I'm going to come back to that sort of really useful framing of the design of the assistant being really important to consumer protection and not just a matter of sort of doctrinal analysis. And Principle 6, protection from manipulation. We heard Therese talk earlier about the need to protect the digital assistant from manipulation by the trader with whom it might be contracting. In Australia, we have a principle of statutory unconscionability, which we borrowed from the US, but it's been given quite a broad interpretation, and I think it would do well with this particular scenario, but I think we also need to give more attention to it. And in fact, in Australia, concern over dark patterns has made us look more closely at developments in both the US and the EU as dealing with those sort of more subtle forms of manipulation of consumers and perhaps digital assistants. So we may see more movement there, I think, in our law. Principle 8 was the conflicts of the principle sort of discussing the problem of conflicts of interest, and I think that came from some of that earlier US writing on these algorithmic contracting, this idea that the digital assistant might in some instances prefer the interests of the trader over the interest of the consumer. And the suggestions made that conflicts of interest should be disclosed, and possibly part of that design principle again. Again, in Australia, we have had case law that said failing to disclose conflicts of interest in online contracting can be a breach of the prohibition on misleading conduct. But I suspect in some contexts, Australian courts would go further than requiring mere disclosure. I'm not sure that really solves the problem for the reasons that John mentioned, that if you tell a consumer, the assistant you're using may prefer someone else's interests, I'm not sure that's going to be salient to the consumer, in fact. And I wondered if maybe at least in high value transactions or high impactful transactions, that conflict of interest simply should not be allowed. I think that could be the result in Australia, certainly in financial markets, but of course they're regulated differently. The lessons of reform that I just wanted to mention for Australia, I've already really mentioned the issue of, well, actually, I'll start again. Australia also has an unfair contract term regime borrowed from the EU. So I found the report's discussion of how that regime, unfair contracts terms, the Unfair Terms Directive, might need to be changed. And I was very interested in the idea of mandating machine readable terms to facilitate algorithmic contracting. That has been discussed in Australia. I think we're a long way from it, but I thought that was a really interesting discussion to allow the digital assistant to really analyse and assess terms and maybe even flag unfair terms in the contracting process. It's a really exciting idea. I know there's already commercial products on the market that are aiming to do this. So the idea of facilitating that through a requirement of machine readable terms, I think is really important and to be considered here. The thing I was most interested in was this focus on ex-ante design. So often when we're thinking about consumer protection, we're thinking about the law that can come in and protect consumers when something's gone wrong or protect them from imbalance of bargaining power. And I think our last speaker talked about that issue. the report is worth reading very closely on the design questions, because what I found most interesting probably about the whole report, all of it was interesting, is this idea that we need to think very closely about the way in which digital assistants that are facilitating contracting process, about their core design features, and the way in which not just privacy by design, but consumer protection by design can be built into those assistants. And some of the suggestions were mentioned by Therese, which is the ability of the consumer to control the parameters of the contracting, to be able to stop the contract going ahead, but also features like lawfulness, transparency, and the like. I felt that was a really useful addition to the debate. And my last point, apart from the point that John made about enforcement and regulated design, is I think we still need future research in understanding the impact of the intervention of an artificial entity between consumer and whom they're dealing with. I'm not sure that the effect of a digital assistant is seamless. I think there is some friction there that perhaps changes the nature of the contracting relationship. The report is actually exploring this, but I think it would be interesting to have more research, perhaps drawing on psychological experiments to see just what the impact is in relation to the trust that the consumer may put in the digital assistance, and also the way in which that changes the relationship of the consumer with the party they're contracting with if they're using an digital agent or digital assistant in that process. And that is all from me.
Thank you very much, Jenny. Thank you very much also for this so-called third-party vision on their principle, because I think your points were very well taken, and really interesting to see how the work of the ELI has or might have also an impact on further reflections in Australia. So we will have, of course, a couple of minutes, not so many, 10 to 15 maximum for questions. But just before, I still need to run a third poll for the US attendees for their CLE credit. And so you still have 10 seconds to answer the following question that appears on the screen. When you are presented with a contract online, do you read the full details before agreeing to the contract? And if you say yes, you're lying. Okay, so we have a couple of seconds more, but I think, well, so we are about at 15%, 15% saying yes. So probably that's, the question is whether you read all the terms and conditions or just overflow them. So now we have time for a couple of questions that could be posed through the Q&A section. But given that we don't have any right now, maybe I have one question to address. We discussed the issue about information and the information model that could be put into a discussion. Especially because with bots, you have a direct information flow, so to say. But now my question goes a bit further, which is, how do you deal with digital assistant to digital assistant contract, so to say? Because we had the impression, okay, we have one digital assistant on one side, but there might be not a battle of digital assistant, but at least digital assistants on both sides. And therefore the question is, what about information requirements in that respect? And how do we deal with, for instance, unfair terms, you said, but maybe on the other side you have a digital assistant that may have countermeasures, so to say, to not be taken by that digital assistant. I don't know who wants to react on that. Yeah, Jenny, you're welcome to react on that.
I was actually going to say, I think that is the interesting question. And that case I mentioned earlier, the B2C2 coin versus B2C2 case, is precisely on two digital assistants contracting. And the court effectively said the parties stand behind those assistants. They've enabled them, so they're responsible for their actions. And I think that's consistent with the point in the Ely report, which I think still applies, that disclosure requirements, information requirements still have to apply, because at the end of the day, it's humans controlling those technologies, not the other way around. But I'm sure Therese and Christophe have views as well.
Yes, please. Teresa, Christophe, do you want to? Yes,
If I
Teresa.
may, yes, thank you very much, Jenny. Indeed, the initial, let's say, the provisional finding, and therefore the conclusion that we got considered in the first part of our project has been precisely to the extent that we want to apply the consumer legislation as it is at the moment, covering, including, and therefore information requirement. It is completely irrelevant to which extent we have one digital assistant for the consumer or two digital assistants representing the trader and the consumer, because at the very end, we are saying that by way of attribution, what we have is still a consumer negotiating with a trader or dealing with a trader, probably not negotiating much. So exactly, at least in our provisional and fast resort, we say information requirement applies exactly at the same level that we are doing in a non-assisted by digital assistant transaction between consumer and trader. Thank you, Jenny, and thank you, Pascal, for the question.
Thank you. I see, John, you wanted to react? You're muted, sorry. Or maybe that's
Yes,
because
sorry
you don't.
about that. Sorry about that. Yeah, I have a way of looking at this. I through some of the writings that I've done about contracts and intentions. So I always say I've delegated part of my mind or my cognition to this AI, right? In other words, we share intentions. So, I mean, this is the idea that, for example, Elon Musk is looking at with the neural link. That's all very physicalist and brain. I'm just talking about sharing intentionality. So if I task this machine to do something, I have actually tasked it to do something that goes to my manifestation of assent for it to do it. I've actually shared part of that objective intentionality that's required for contracts to this machine. That's what's happening, essentially. That's how I look at it.
Thank you very much. And of course, as both Christophe and Teresa mentioned during their presentation, we have these two different contracts. And the question is, to which contract is information more important? Probably the contract where you buy the bots than when you use the bot, because then you have already a lot of settings, a lot of things that have been preempted by the first contract. But I don't want to run the show alone. So I see there's a question here about the order of the principles. And the question is, might they be rearranged based on the type of consumer journey or of the consumer journey, so that you could just go along the principles and say, okay, now I understand, here we are at the birth, at the life, and maybe at the death of the contract or the consumer journey. Christophe, you want to react maybe?
Yeah, definitely. I think that there are various ways how the principles can be presented. With principle one, we started with a core issue of attribution. Without attribution, there is no contract, so all the other questions maybe won't arise. So that's why we started there. And then the next thing we said is, oh, consumer law applies. And then we did a bit of a contract cycle or a customer journey approach when we the third principle was about pre-contractual information duties and so on. But I agree that for the second phase of the project, we will probably rearrange this, and especially since principle 8 is most relevant for contract 1, whereas the other principles rather focus on contract 2. So I think that there will be some reshuffling for the second phase, definitely, yeah.
Thank you very much for this. I don't see further questions. Maybe I should dig into my whole set of questions. One question seemed to be interesting, and it's the relationship between contract and regulation. And of course, in the EU, in the European Union, powers to regulate contract go mainly through EU consumer contract law, because ordinary contract law is still in the powers of the member states, which might explain also why the EU has this very regulatory perspective. Now, my question, because that was prompted by John's remark, we have to have a high level of protection for consumers, but at the same time, we should empower the consumers. So is there a way out of regulation? And is it the death of contract when one speaks about consumers? I don't know who wants to react. Maybe Florencia. Yeah, please.
It's a really interesting question because I'm teaching an internet contract seminar now, and of course that and John raises this as well, and I alluded to it when I said, well, maybe now bots can read for us, and this fiction of assent can be given some legitimacy, even though not by humans. The whole notion of contract rests on this idea that it's this voluntary thing, and we don't look so much into the terms of it because we assume that we know what we're getting into. And if we have this autonomy that we know what we're getting into, if we agreed to be in this contract, it must be because we're better off than not. Of course, all of this is in the consumer context is based on the fiction that we know what we're getting into. We have mass market contracts. The contracts are extremely convoluted and complex, and nobody reads anything at all. And so this notion of voluntariness and that we know what we're getting into is somewhat compromised. Of course, it would have been regulated fully if it hadn't been for this belief that we might have other agents. Now it's bots, but it's other sellers or the market or competition or agencies or ex post litigation, right? The class action has been a way in which through the back end we internalize consumer interest. So the jury is still out as to the extent to which competition is fully taking care of consumer interests. The fact that we're boundedly rational means that the competitive outcome might be one that sellers that don't exploit are the ones that get taken out of the market. Full-on regulation might mean the end of contract, and we need to know more about, now with this new deployment of bots, whether we can reinvigorate the autonomy of the consumer through agents, or whether we're going to end up in a situation where there's just pure market failure. One thing that we do know is that as much as there are lots of problematic practices, as somebody who's been reading these fine print contracts for decades now, the contracts are not as terrible as they could be, which is somewhat puzzling. If we're in a world where nobody's reading and everybody is taking advantage of consumers, that's not entirely what we see. So it's much more complex than that. We're not in a situation where everything should be regulated. Now, what should be regulated is also a problem. We're dealing with a very innovative industries and legislatures, not the EU, but everywhere else takes their time to do things. And there is a true cost to innovation and to choice if we are fully to regulate everything. So these are not easy questions, but the fact that they're not easy shouldn't be the case that we shouldn't have them. So documents and efforts like the ELIs in this particular context are quite interesting. One other thing that is true is that putting out information when we know nobody reads it doesn't really do much at all either. So perhaps deploying digital assistance might help in this direction. But these are really hard questions, and I think we're all rolling up our sleeves and addressing them in ways that are important and moving away from fiction, which I think is a really important step.
Thank you very much, Florencia, for that. I fear that if everyone is speaking, we might not end on time. And as a Swiss, I want to end on time, and also for other reasons. So maybe I will just stop here, because I think what you have just said, Florencia, about, and that was also said by Jenny, the importance to continue to work on that, to see what are the consequences and try to understand what happens. Because now we know that consumers are partly irrational, but what are the results between this interaction between irrationality of the consumer and a kind of digital rationality of bots, and that might be also an interesting aspect. So thank you very much. Before some concluding remarks, let me just put on the screen the final poll question for our US attendees. You still have 10 seconds to answer this question, which is: after attending the webinar, will you reach for the ELI restatement or the ELI report in your work teaching or other projects? And of course, here, you better say yes. Uh, I'm not trying to influence the results, but I see two people decided to say no, which is perfectly fine, of course. Thank you very much for this. Let me just thank our wonderful panelists. I think the discussion and their presentation were very rich. We were really in a position to understand what is at stake, and I think it gives also appetite for further reflections and probably for further webinar in the same sense. So thank you very much to all 6 of you. Thank you also for the ARI to agree to in a way celebrate this centennial, to have these joint seminars and webinars, because I think this brings a lot to both sides of the Atlantic to try to understand each other better. And of course, with Australia as well, we go further in this exchange. And may I just say also for our US lawyers seeking CLE credit, I have to say that for this event, please fill out the form that was provided along with the other course materials and follow the instructions on that form to submit it for credit. And above all, thank you to everyone for attending this panel. I wish you a wonderful day, night, or evening, depending where you sit. And I look forward to the next webinar, ALI, ELI webinar. Thank you very much and enjoy. Bye-bye.